Thank you very much. Sorry, it took a bit of time. There's a lot to discuss. The subcommittee listened to all representations made, both oral and written. The subcommittee considered all the relevant evidence made available to it, and in doing so took the following into account: the Licensing Objectives, Licensing Act 2003, Hillingdon's licensing policy, and guidance issued by the Secretary of State under Section 182 of the Licensing Act 2003. Having taken into account all the evidence and submissions made, the decision of the subcommittee is to refuse the application. We considered the Old Dairy area already suffers with existing problems of antisocial behaviour. We saw evidence that the Asda car park, which neighbours the premises and is part of the Old Dairy development, is a particular focus for antisocial behaviour. And Councillor Takwell gave evidence that only last night there was a significant incident in the car park requiring a large police presence. There are no other comparable licensed premises either in the Old Dairy development or nearby, which are open for licensable activities throughout the night. There is a 24-hour licensed petrol station. Right, there is a 24-hour licensed petrol station development, but this is not licensed and is a very different kind of business. We were also told that as things stand today, as that closes at 2300 Monday to Saturday and 1700 on Sundays. Nando's also closes at 2300. Cineworld's closing times vary, but it seems unlikely that they will remain open much later than 2300. Therefore, we are concerned that as the only venue open until 5 a.m., there is a high risk that the premises would act as a magnet for people who would not otherwise be drawn to the area. This could make worse existing problems of antisocial behaviour. We do not accept that there are no residential properties opposite the premises as the applicant contended. We are familiar with the layout of the development and agree with the licensing authority that the nearest homes are around 50 metres away from the premises. Anyone driving to the premises and parking in the Asda car park will pass very close to these homes. Although we are aware that planning permission was granted for a mixed-use development, including commercial and leisure use, we consider that the area around Arla Place remains relatively quiet at night. Therefore, we agree with the licensing authority that there is a real potential for noise disturbance to residents of Arla Place from residents coming and going to and from the premises late at night. In particular, we do not consider that the applicant had a clear plan for dispersing customers leaving the premises. We were told that members of staff were not instructed to go beyond the premises boundary to deal with the incidents or to carry out litter picking due to safety concerns. There was no suggestion that door supervision would be deployed, although we note that outdoor dining area would be closed off. We consider that there remains a risk that customers would linger outside the premises, causing noise disturbance, who would carry to the nearest properties. If dispersal is not being actively managed, they may then leave through the residential areas, causing disturbances as they go. We agree with the applicant's point that beyond the immediate vicinity of the premises, customer behaviour is a matter of personal responsibility. However, this does not answer our concern that the premises would draw people into the area at a sensitive time of night who would not otherwise be there. In any case, the immediate vicinity, of course, is a matter of judgment for us. We also note that for litter picking purposes, they were prepared to accept a fairly wide zone of responsibility, potentially extending as far as the playground. The applicant has not carried out any consultation with local residents, which, along with the way in which this issue was addressed by the applicant during the hearing, struck us as dismissive of this important area of concern. We note the proposals to manage deliveries and delivery drivers, including mopeds, would be routed to the rear of the premises to a dedicated collection area. However, we also note that the licensing authority is concerned that these measures may not be watertight and that in practice, drivers could congregate in and around residential areas, causing disturbance, which is not clear to us what the applicant would do or would do about that. We bear in mind that planning permission has been granted for the premises and the wider development. However, as it was pointed out, planning is a separate regime, and this subcommittee is under a clear duty to consider this application in light of the licensing objectives. We also know that neither the police or the environmental health objected to the application. However, the licensing authority did object and maintained their objection based on the public nuisance licensing objective. despite the applicant's agreement to the proposed conditions of 1 to 3. We also consider whether granting the application subject to conditions would address our concerns. However, our objections to this application is fundamentally about hours of trading, which is not something that could be addressed by conditions. The applicant did not propose, as an alternative, reducing licensable hours and explained the commercial reasons for seeking the hours in the application. Licensing is prospective, in that we are concerned about the risk to the licensing objectives if the license is granted. We are aware of the right of review in case problems do materialize. However, we have decided there is an unacceptable risk that the licensing objective of preventing public nuisance would be undermined if we were to grant this application. For the reasons set out, we consider this inappropriate to refuse the application. The relevant applicant for the premises license or any other persons who made relevant representations to their applications may appeal against the council decision to the Justice Clerk at the Uxbridge Magistrates Court. Such an appeal may be brought within 21 days of receipt of this notice of decision. No decision made by the council will have the effect during the time period within which the appeal may be brought until such time that any appeal have been determined or abandoned. You'll be deemed to have received this decision letter 2 days after the date of the company letter, which will be posted by first-class mail. Thank you very much.